I now give the floor to His Excellency, Mr. Antonio Miloshoski, agent of the former Yugoslav Republic of Macedonia.
Distinguished President, first allow me myself, on behalf of my government, to associate with the condolences and the sympathies that you have presented for the people of Japan. All our countries will give its contribution to support in this strategy. Distinguished President, distinguished members of the Court, my government is exceptionally honored to appear for the first time before this Court, the principal judicial organ of the United Nations, which serves as the paramount guardian of the international justice. At the outset, I hope you might allow me to express my deepest respect to the members of the Court, availing myself of this opportunity also to congratulate Professor Emanuel Rukunas and Professor Budislav Vukas for their appointments as ad hoc judges in this case. I should also like to express my appreciation to you, Mr. President, and members of the Court, for the flexibility you have shown in scheduling this hearing. We are fully aware of the Court's caseload and the time constraints that you are dealing with. If you allow me, Mr. President, members of the Court, at the very outset of this case, I would like to pay my respect and express my profound appreciation to the late Professor Thomas Frank. He appeared before you on a number of occasions with a great distinction, and he also served as an ad hoc judge. He was an invaluable part of our legal team, and in the very last days of his life, we were privileged and honored to draw inspiration from his sharp thought, iron logic, and noble spirit. Mr. President, since winning its independence peacefully in 1991, 20 years ago, the Republic of Macedonia has been committed to peace, the rule of law, respect for human rights, and peaceful resolution of international disputes. We are a multi-ethnic democracy pursuing a policy of good neighborliness and regional cooperation. We have joined the international community in its efforts to bring lasting peace, stability, and prosperity in the Balkans, and in integrating the Balkans into the European Union and North Atlantic Treaty Organization. Indeed, at key moments during the last two turbulent decades in the Balkans, my country has been an important part of the solution, not part of the problem. In the early 90s, during the breakup of the former Yugoslavia, we were fully aware of the danger of an armed conflict spreading to our country, so that as early as 1992, upon our request, we hosted the first preventive deployment mission in United Nations history. This mission, aptly titled the United Nations Preventive Deployment Force, or UNPREDEP, helped stabilize our security situation. Further, through the 1990s, we built a multi-ethnic society, developing a strong system for protection of human and minority rights. In 2001, when my country faced severe internal crisis, it was the maturity of the Macedonian citizens and the moderation of our leaders, supported by the European Union, the North Atlantic Treaty Organization, and the other international actors that brought about political solution to this crisis. The conclusion and implementation of the Ohrid Framework Agreement, along with NATO and EU-oriented reforms, additionally contributed to my country's role as an active provider of security. In the spirit of the good neighborly relations, my country has regulated its borders with all our neighbors in a peaceful way, respecting international law. Today, we participate in several peace missions in other countries. For example, we participate in the European Union's Althea mission in Bosnia and Herzegovina, charged with implementing the Dayton Agreement. We participate in the International Security Assistance Force, ISAF mission, in Afghanistan, working closely with the North Atlantic Treaty Organization. For nearly 2 years, our military medical staff in Afghanistan has had a joint mission with our Greek colleagues. Given our constructive policies and performances at home, but also abroad, we had been well on track to be invited to join NATO at summit in Bucharest 2008, together with Croatia and Albania. Mr. President, the Republic of Macedonia has a strong interest in and continues to develop friendly relations with all countries, including the Hellenic Republic, the respondent in this case. Regretfully, our bilateral relations are burdened with the unfortunate issue of the difference over the name of my country. Though resolution of this issue is not before the court in this case, let me provide you some background. The respondent raised concerns about my country's name following our peaceful proclamation of independence in 1991. This difference caused a serious delays in the process of international recognition by other states, in the integration of my country into United Nations and other international organizations, and in the development of our relations with the respondent. The Greek-Macedonian dialogue on the difference over the name started in 1993. Since then, we have actively engaged in good faith negotiations with the respondent under the auspices of the United Nations in an effort to resolve that difference. We regretted that in 1994, our neighbor decided to introduce a unilateral embargo on trade and transit of goods between our countries, and sought to obstruct international recognition by other states and impede our membership in international organizations. It was the interim accord that both parties signed September 13, 1995, that created the legal basis for normalization of relations between our two countries. Today, after more than 15 years, we can say that in general, the interim accord has worked successfully. It has largely enabled both parties to put behind them a period of tension and to open a new chapter of bilateral cooperation and providing an impetus to good neighborly relations and understanding. In particular, the interim accord contributed to the removal of the respondent's economic embargo, and for a period of 13 years, removed an impediment to our successful integration in the international community, allowing us to join international organizations such as the Organization for Security and Cooperation in Europe and the Council of Europe. In recent years of negotiations, as previously, the parties and the personal envoy of the United Nations Secretary General, Mr. Matthew Nimitz, have tabled various proposals which have been accepted as a basis for a solution or rejected by the one or the other party. In October 2005, we accepted a proposal by Mr. Nimitz which, according to his correspondence to both parties, meets the minimum requirements of both sides and thus should be the basis of an honorable and acceptable solution. Previously, the same year, the respondent accepted a different proposal by Mr. Nimitz. In March 2008, immediately before the NATO summit in Bucharest, my country accepted a proposal by Mr. Nimitz, and we expressed the readiness to put it for a vote before the Macedonian citizens on a referendum. Unfortunately, the proposal was rejected by the respondent. Instead, and in contravention of the interim accord, the respondent resorted to objecting to the extension of an invitation to my country to join NATO. In the period from November 2009, The Greek-Macedonian dialogue concerning the name difference has continued in parallel with high-level leadership meetings between the two countries. As recently as last month, Ambassador Nimitz commended both countries in the ongoing name negotiations, stating, I quote, "Both sides expressed a positive attitude towards moving forward on this issue. I think the biggest development of the last year has been the dialogue of the two prime ministers, 8 meetings between them. In my view, this has had a positive effect, starting to build trust and understanding at the highest levels." End of quotation. Mr. President, members of the Court, I convey that information simply as background for your understanding of the present situation. Contrary to what the respondent may say, in this case before you, we do not seek that resolution of the name difference, either directly or indirectly. This is and remains the object of the mediation process under the auspices of the United Nations. What do we seek in bringing this case? This case has been brought to ensure that the respondent uphold one of its key obligations under the 1995 Interim Accord. Nothing more and nothing less. Our application concerns the respondent's violation of one aspect of the provisional regime established under the Accord, an obligation that has enabled the normalization of bilateral relations pending resolution of the name difference. Specifically, our application concerns the respondent's obligation under Article 11, Paragraph 1 of the Interim Accord, which had been respected for nearly 13 years following the entry into force of that agreement. By its conduct in the period leading up to and at the Bucharest summit in April 2008, the respondent violated Article 11, Paragraph 1 by objecting to our accession to NATO, even though it was clear and not in dispute that we were to be provisionally referred to in that organization as the, quote, former Yugoslav Republic of Macedonia, unquote. Indeed, that is the reference by which we are known in our contribution to NATO's efforts in Afghanistan since 2002. Yet, in 2007 and 2008, the respondent reverted to its pre-1995 practice, bringing to an end our ability to join international organizations of which the respondent is already a member. We very much regret this action and hope that the Court will assist the parties in returning to the system that was envisaged by the Interim Accord. This would enable us to continue to pursue membership in NATO and the European Union, a goal that we have had since 1993, and this is of tremendous importance for the internal stability of the Macedonian multi-ethnic democracy. The European and Euro-Atlantic integration has and will contribute to the stability in the region. Mr. President and members of the Court, this is a simple and narrow case of pacta sunt servanda. For a reason not permitted under the Interim Accord, the respondent objected to our membership in NATO. The respondent seeks to present this case as a complex one and advances a series of strained or irrelevant assertions, as well as novel legal and factual assertions that were not raised before April 2008. Its arguments appear to be designed to obfuscate what is rather straightforward violation of a straightforward obligation in the Interim Accord. In its pleadings, the respondent pursues 4 central arguments. First, the respondent insists that it may object if my country uses its constitutional name when communicating with international organizations or other countries, or even when other countries use the name of my country. The interim accord, however, allows no objection on that basis. In any event, there are no facts supporting that basis as a true reason for the respondent's objection. Indeed, the respondent goes so far as to claim that the reference, quote, former Yugoslav Republic of Macedonia, unquote, is the provisional name of my country and that there is an obligation erga omnes for its use, including by my country. Yet, such a claim is fully contradicted by the text of the Security Council Resolution 817 from 1993 and the statement of those who drafted that resolution. Such a claim is also contrary to the long-time understanding of this resolution as applied in the practice of the United Nations, of other international organizations, and of third states. This understanding was even confirmed by Mr. Nimitz himself upon the conclusion of the interim accord in 1995. We note that the Hellenic Republic itself has agreed to accept official correspondence from the Republic of Macedonia in one of the bilateral agreements concluded to put into effect the interim accord. Second, the respondent attempts to justify its breach by creating the impression that there have been violations of the interim accord on our side. This is a false assertion, to which we have responded in our pleadings. Yet more importantly, it is an argument concocted ex post facto. At no point before April 2008 did the respondent inform us that it considered us to have been in material breach with the interim accord, and that it intended to suspend in whole or in part the interim accord. Nor did it inform us that it intended to pursue countermeasures if any alleged breaches on our part were not remedied. In this way, the respondent seeks to sidestep the law of treaties and the law of state responsibility and to replace one stable system of treaty relations with rights unilaterally accorded and determined. Third, the respondent repeatedly mischaracterizes our claim by insisting that this case is about NATO's conduct, over which the court has no jurisdiction. Let me be clear. We are not asking the court to issue any declaration or order in respect of NATO or any other international organization. We ask only for an assessment of the actions of the respondent undertaken at the time when NATO was deciding on the extension of an invitation for membership to my country. We ask for a declaration that the acts of the respondent represent a violation of its obligation under Article 11, Paragraph 1, together with an order that the respondent must in the future abide by this obligation in respect to our accession to NATO, to the European Union, and to other international organizations of which the respondent is a member, so long as we are to be referred to in such organizations as provided in the Security Council Resolution 817. Fourth, the respondent seeks to justify its breach of Article 11 by pointing to a different article of the interim accord, Article 22, which the respondent says allows it to object when exercising rights under the North Atlantic Treaty. While I will leave the legal arguments in this respect to our legal counsel, allow me to make one observation. If one accepts this reasoning, which is contrary to the plain meaning of the provision, Article 22 would completely eviscerate Article 11, denying to my country one of the central reasons why it agreed to the interim accord. By granting the relief sought in our application, the Court will reaffirm the fundamental principle of pacta sunt servanda and ensure respect for the provisions of the interim accord. Our stability and our ability to secure membership of international organizations must not be instrument for the respondent to impose his preferred solution for overcoming the name difference. This is exactly what the Article 11 of the interim accord was meant to prevent, and it did prevent for 13 years. Mr. President, our decision to institute proceedings with the court was not an easy one, nor was it taken without serious considerations. However, we were left no other choices. We followed the path that the respondent should have taken. If it truly believed that we were in material breach of the interim accord, it could have instituted proceedings against us under Article 21 of the interim accord, or invoke the procedures provided by 1969 Vienna Convention on the Law of Treaties, or the proceedings envisaged under the rules applying countermeasures. It did none of these things. Instead, it took the matters into its own hands and acted outside the law. By contrast, we have followed the prescripts of the interim accord and initiated these proceedings. When the parties concluded the interim accord, they agreed on the jurisdiction of the court to settle issues deriving from the accord, with the exception of the name difference itself. The applicant asks the court to hold the respondent to its obligation under this extremely important bilateral instrument, concluded exactly for the purpose of ensuring the legal framework for development of good neighborly relations. I am pleased now, Mr. President, to let you know how the case will proceed. I will be followed to the bar by Professor Philip Sands, who will deal with a number of legal and factual matters predating the actions of April 2008. Professor Sean Murphy will then address the NATO membership process and the events leading up to and including April 2008 and the respondent's objection to our membership of NATO. Professor Pierre Klein will then deal with the first part of our arguments, explaining why the respondent is wrong to assert that the court lacks jurisdiction and that our claim is inadmissible, an argument he will conclude tomorrow morning. Following on from there, we will address in detail the circumstances in which the respondent has violated Article 11, paragraph 1 of the interim accord. We will then conclude the morning with submission on why the respondent's violation of Article 11, paragraph 1 cannot be excused by the law of treaties or the law of state responsibility or any other newly embraced rules or principles of international law. We will also address the remedies that we seek. Finally, we will bring our presentation to an end with some brief concluding remarks. I take the opportunity to express my thanks to Ms. Bline Nigralich for her important contribution. She expresses her regret for being absent this week due to personal family reasons. Mr. President, members of the court, it is truly a privilege for me and for my country on the occasion of its first appearance being here in this court. I will remain available to provide such assistance to you as you may need from us throughout these proceedings. And now I invite you to call on Professor Sands. Thank you for your attention.